A trusted face in the classroom, now at the center of a criminal investigation. In North Carolina, a substitute teacher is behind bars. She's 33 years old and charged with the statutory rape of a child under 15. Now she sits in a county jail, and if she's convicted, she could spend years, maybe even decades behind bars. I'm Kennedi Walker, and I'll walk you through what authorities say happened, plus we'll take a broader look at a troubling pattern. Teachers and educators, people entrusted with your children, allegedly crossing a line that should never be crossed. For 7 months, Katelyn Schronce worked inside classrooms across the Catawba County school system. Like any substitute, she was trusted to step in when a full-time teacher couldn't be there. Trusted to supervise, support, and guide children through their school day. But according to authorities, behind that role of responsibility was something more disturbing. Court documents say the alleged crime happened on March 29, 2025. The state alleges that Schronce, quote, unlawfully, willfully, and feloniously engaged in vaginal intercourse with a child. The victim's exact age has not been released. But based on the charge of statutory rape of a child under 15, we know the child was no older than 15 years old and possibly younger. Schronce, who was 33, was arrested more than 2 weeks later. Authorities have not said how the two know each other, and right now it's unclear if the child was one of her students. What we do know is that she had access to children for months. The school district quickly cut ties after her arrest. In a statement obtained by WCNC, they wrote, quote, "There is no indication at this time that the charges are connected to her employment in our district." Ms. Schronce began serving as a substitute in October 2024 and has been immediately released from her duties. The safety and well-being of our students is our highest priority, and we will continue to cooperate fully with law enforcement as their investigation continues. But the headlines do not stop there. Outside of Houston, Texas, an orchestra teacher was arrested for allegedly having sex with a middle school student. Kara Hernandez was taken into custody on Valentine's Day of this year, but the accusations go back to 2022 when she was teaching at Ronald Thornton Middle School. According to court documents obtained by the Daily Mail, the alleged incidents happened twice, once in April and again in October. The documents say Hernandez allegedly had the student touch her genitals, quote, with the intent to arouse or gratify the sexual desire of herself or the minor involved. Hernandez resigned in September of 2024 after a former student came forward. In a letter to parents, the Fort Bend School District said, quote, recently allegations of past inappropriate conduct by a Thornton Middle School staff member were brought to the district's attention by a former student. Fort Bend ISD immediately began an investigation, and the staff member was immediately removed from the campus and placed on administrative leave pending the outcome of the investigation. The staff member will not be returning to FBISD. Hernandez now facing 2 charges: indecency with a child involving sexual conduct and an improper relationship between an educator and a student. Her bond is $50,000. 2 teachers, 2 mothers, 2 women who held authority over children are now accused of abusing that power. For parents, it's a reminder: not every danger your child faces is outside the school walls. And joining me to talk more about this is legal expert Patrick Roberts. Patrick, thank you so much for coming on today. Let's just jump right in. Can you break down her charge and share how many years that she could be facing?
So based on the charges that I've seen online, and a lot of information hasn't come out yet, but it appears at least 1 count of statutory, looks like statutory rape actually, and that's a minimum in North Carolina of 12 years, mandatory minimum. That's the least that a person could get with good behavior, with a great criminal history, that basically no convictions. The least a person can face, or she would be facing in this situation, would be 12 years. It can go up
Wow.
to 30 years, but that's the range, minimum of 12.
And how does a person, how do they dictate whether it's 12 or 30? What does a person need to be charged with to reach that maximum?
Well, in this case, it appears from the headlines I've read that the individuals under the age of 15, that's one factor. There's a difference. I think I saw an age of about 33 years old for this woman. The minimum is if there's a 6 year gap in age when the person is also the victim is also under 15. That makes the charge a Class B1 offense, which is one level below murder in our state, frankly. And that's how you determine, or at least the starting point for determining the punishment that a person may be facing. Then you need to understand if that individual has convictions. Those are the factors that may apply. Also, other factors to consider in this case, which would be important, whether that person's in a position of trust, i.e., like a teacher or a substitute teacher, whether they have any level of control or any amount of coercion was used. So there's some things to factor in that could also raise the potential punishment.
And I was just about to ask, how does the legal system typically treat cases involving educators accused of crimes? We know that Katelyn wasn't a teacher, but she was a substitute.
Mhm. It draws no distinction between substitutes and fully employed teachers, and it's generally pretty harsh. The system goes after, if you will, those individuals, and in many instances tries to make examples of them. The offers, if there are any, for possible plea resolution can be pretty severe.
And what factors do prosecutors weigh when deciding whether to pursue just maximum penalties in cases involving school employees?
So some of the main factors really is based would be based on the strength of the case. What evidence they have to confirm that a sexual encounter or more than one sexual encounter occurred, such as digital evidence, cameras in the school and anything that may have been captured, confessions or statements made by the person accused, the interest and the concerns of the family and the community more broadly, but specifically our laws require that the family of the juvenile be consulted and given an opportunity to offer their input into what outcome they would like to see with the case.
Yeah, and at this point, we don't know how exactly the suspect and the victim know each other. We don't know if they met when the suspect was substitute teaching. At this point, we're learning more information. But can a teacher be charged as both an individual and a public servant? Can you explain the legal significance there?
Well, in North Carolina, we have actually two different potential criminal charges. There's one for an individual who is a substitute teacher, and there's one specifically just for a differential between the ages of individuals. So, any person under the age of 16 in North Carolina cannot give legal consent to sexual encounters with an adult, and a person could be over the age of 16, maybe even 18, but as long as they're still a student, if the older individual happens to be employed in some capacity with the school system, sometimes even as a volunteer, they could still be charged with a crime. It would just not be as severe in terms of punishment.
How might plea deals come into play? What happens if the victim doesn't want to testify? Does the case just get thrown out?
On occasion, yeah, that's fairly rare. However, especially given the community interest in the outcome of the case, if there was a lack of interest in testifying or going public, that might impact what's offered by the state. There are ways to offer, deferred prosecution outcomes. There are ways to reduce certain charges to misdemeanors or to charge ulterior, different types of charges. It's fairly rare in these instances, but it's not unheard of.
And again, we do not know how the suspect and the victim know each other, but let's just say hypothetically they did cross paths while she was substitute teaching. Can the student or the parent take civil action against the school or district in a case like this?
It's possible. It really would depend on whether the encounters took place during school hours, whether it was something that was known by any member of the faculty or the people in administrative lead positions, and whether or not the school took no action. If the school was slow to respond, if someone knew, then that could be an issue that raises potential liability concerns.
And you just mentioned not too long ago that in cases like this, sometimes prosecutors like to make examples of the suspects.
Mhm.
Could a case like this set a legal precedent for future misconduct cases in schools?
The part of the purpose of the criminal law is not only to punish the individual charge, but also to defer or deter future conduct. So the hope would be if you are, let's say, more harsh with this individual, that other people who may consider similar conduct wouldn't take action because of the fear that they may be next.
And can you just walk us through the guidelines here when a student, reports an incident of alleged abuse? Are there legal guidelines around how schools must respond to accusations before a conviction?
Well, there are requirements for disclosure of anything involving alleged child abuse, and this would qualify as an alleged incident of child abuse. There are reporting requirements for all school personnel. So within, I wouldn't even say 24 hours, it would be immediate. There's not really a time frame, but as soon as a person is aware, or in some cases should be aware, there's a reporting requirement that would cause them to have to notify perhaps child protective services, administrators, other school personnel for the benefit and safety of and protection of the child.
How does an arrest like this affect, a teacher's certification or ability to work again?
That's a different sort of parallel line, if you will. The criminal charge will almost invariably cause an individual to lose their license or at least be subject to professional discipline and licensing discipline. They do have the right to due process, and so the criminal matter will likely resolve before a disciplinary hearing might take place, and they still could in theory, preserve the license. But frankly, what I've seen in most instances, most people resign. And often, if there is a plea deal, they surrender their license as part of a deal, especially if that means that they're avoiding, prison time or a lengthy prison sentence.
And, speaking of that, we almost always see school districts terminate the accused teachers before a trial, which is what happened in this case with the substitute teacher, happened in the other case in Houston. If everyone is innocent until proven guilty, how are they able to do this? How do they justify letting people go before a trial even happens?
Well, the criminal standard is higher than the civil standard. We're talking about proof beyond a reasonable doubt versus, in many cases, preponderance of the evidence, which is 51% or more. You don't need much. And in some cases, if the school feels confident in the evidence that they have, that the end result will be a conviction or something that, causes the person to have criminal consequence, then they might move forward ahead of time. Uh, Bear in mind that a lot of these school systems have outside counsel. And so they're looking at the liability side of things and the risk of having someone with a pending charge of this nature on campus is generally just too great to take, that chance of keeping them around.
But if a teacher is later found innocent, can they potentially even sue the district for defamation or reputational harm?
Potentially, they may even back pay and any other remedy that may be available. They have to get past the hurdle of a prosecution wall first. They have to win, but that may be an avenue that's available if they're ultimately cleared of the allegations.
And we just spoke about, what teachers are supposed to do whenever they, get these allegations. But what is the process for law enforcement when investigating educators in schools?
So the law enforcement and the school administration generally work hand in hand. Many teachers are under certain agreements where they have to, if you will, cooperate or at least be willing to cooperate if they want to preserve their job. So that puts the teachers, frankly, in a somewhat of a difficult position. If you make a statement consistent with your job requirements, that could be incriminating. But law enforcement certainly will rely on the opportunity to use the employment relationship to further their investigation, bringing in the teacher, using the principal as the lead in a questioning authority, if you will. Sometimes they may even allow the principal or the vice principal to do the questioning, rather than have a police officer in place, because that triggers different constitutional rights, or may not, depending on the circumstances.
What challenges do investigators face when collecting evidence on school property? Is it just they don't think that the teachers would trust them, or do you think it just how do they go about that? I know you just said that sometimes they let the principal and the vice principal do that. Is that a comfort thing?
It's comforts generally, but also strategic. The employees of these schools, as I said, many of them have obligations to cooperate with investigations, and they don't necessarily need to be told that these, any statements they make could be turned over to law enforcement. So, if you're a law enforcement officer, you come onto school grounds, you flash your badge, that may cause someone immediately to say, "Oh, maybe this is a little bit more serious than I initially thought." May cause them not to want to answer questions. And so sometimes falling back and allowing the administrators to do the initial questioning may be advantageous. Ultimately, if this is going to be a criminal matter, then law enforcement will need to engage that individual. But early interviews may be helpful to law enforcement, and can be done by school personnel instead of the officers themselves.
Well, when it is done by school personnel and not the officers themselves, can officers use their statements as, a part of the trial, or not really, because it's not like they were Mirandized or anything like that because it wasn't done by an officer?
Well, that's sort of an end around. I mean, you mentioned the Miranda warnings. Law enforcement, if they're taking a person into custody, has to give Miranda warnings, or if there's, really even a possibility of that circumstance. But school personnel aren't under those same obligations. They can conduct their investigation, and it leads where it leads. I mean, in theory, you may be asking a teacher about something, and they may deny it completely, and that's not very useful to law enforcement necessarily, but you have to take the answer that's given. Due process, the teachers are entitled to due process, but that's much more along the lines of maintaining their employment than along the lines of protecting their rights vis-a-vis self-incrimination.
As a parent, what should you legally expect in terms of transparency from the school? I'm not talking about the parent of the victim, but just, your child goes to the school where a substitute teacher was just fired and accused of these heinous crimes. How should they, be kept up to date?
I've seen many schools, and most schools have a policy of maybe sending out a mass email, or mailings to the parents to notify them about the different developments. If the person is still employed, how that process is going, whether the individual has been placed on temporary leave. They don't go into details with regard to the allegations, but they give some vague sense of what has been said to address rumors that are certainly going to float around when a teacher is under investigation for any sort of misconduct, especially where sexual encounters are involved.
Are parents allowed to request records or even internal reports involving the accused?
Uh, Generally, no, not at the initial stages. Eventually, um, certainly the parents whose child are children are involved certainly might have more rights with respect to that. But broadly speaking, parents whose children are not connected to the allegations would not.
Well, how long could a case like this realistically, take to go through the courts? Are we talking about months, years?
Years more likely. Not knowing any details about the defense that may be raised, or the strength of the state's case. In my experience, I've handled hundreds of these on both sides. I would say 18 to 24 months is usually about the standard period of time from start to finish to resolve it, either by trial or by plea or dismissal. But generally around the 2-year mark, you would expect to have some resolution.
And, if you were the suspect's defense attorney, how would you battle this case?
I don't know this case. I'm not familiar with this situation. I believe I've had some cases in Catawba County, but the first thing I would want to look at, are the statements of the person making the accusation. I'd like to know if my client made any statements. I'd like to know if there's any digital evidence trail of any sort. whether there's any video evidence. I might be inclined to find out if there's GPS evidence to, connect my client to a specific scene. Oftentimes, if it's alleged that, the incident occurred on school grounds, then you want to see whether the client was actually working. I mean, my understanding is this person was a substitute, and therefore they would have a limited schedule. So I would want to know, if the claim is that the person was working or the encounter happened on a Wednesday and she's not working on a Wednesday, that certainly presents a defense. So you want to know sort of physical location as a starting point, and compare that to the claims or the allegations to figure out, if there's any possibility of the allegations being true.
And testifying can be scary, especially for children. How are, children protected during this process? Or what do, the prosecutors tell the parents that, hey, you know what, we should do this and everything will be okay, their names will be hidden? Walk us through that process. How does that go? Because I'm sure that a lot of parents going through this scary situation, they don't want to put their kid on the stand.
First of all, when prosecutors indict for cases like this in North Carolina, they most of the time will use the initials of the child and never the full name. So that's the first thing. Date of birth may be disclosed, but the initials will not be. So that will not be part of the public record. Okay. When a child testifies, their name is never to be in a newspaper, or it's redacted if there are any public documents that may contain or for some reason need to contain the child's name. But normally, the courts go out of their way to protect the identity of the child, the full identification of the child in terms of, factors that could be used to someone to decipher their true identity. Those things are just not allowed, and there can be court orders, regarding that issue. Sometimes the courts can be closed when the child is testifying, so maybe the media might be allowed if they petition the court, but sometimes the courts are just closed. So if the child is testifying, everyone that is not connected to the case has to exit the courtroom until the testimony is finished. Then people can return. So there are definitely steps taken to protect the child and balance the First Amendment right of the public and the press with the privacy right of the child as well.
All right. Well, this is something that we will definitely be following closely. Patrick, thank you so much for coming on today.
Thank you.
Katelyn Schronce is being held in the county jail, and her bond is $250,000. For Law and Crime, I'm Kennedi Walker.